we are speaking about a new era in employment relations in Barbados. And this is something that the labor movement has been excited about for some time now. If one can only recall a number of our press conferences, a number of appeals to government, the DLP administration, and before that, the BLP administration, it was that we need workers' rights to be enshrined in law. Barbados operates under a system of voluntarism, not to be confused with voluntarism. Voluntarism, T-A-R-I-S-M, meaning that we don't depend, or traditionally we have not depended a lot on the labor laws. What we've depended a lot on is meeting around the table and discussing, negotiating, bargaining on issues and reaching an amicable solution. Not a solution that satisfies everybody, but a solution that is the fairest one that can be derived at the point in time. And both parties, whether employer or employee, would walk away respecting generally, although we have some unscrupulous employers. And we have some workers that are not saints, who do not honor the commitment. So while I'm not employers, I am quick to recognize that those who we represent do not always keep faith and keep the image that we would want. And Minister, one of the things that you will see coming from time to time before you or hear about would be those employers who complain that we pay the employees who out on sick leave and they don't return the NIS refunds. That embarrasses the union because we have worked so hard over the years to get benefits for workers, and it's not for workers to take advantage or abuse, but it's for workers, as you heard, to live up to their responsibilities. And I start off there because I'll take out my belt for the employers later, so I just open it up so that Peter Earl doesn't have anything now to flog me about. I've already flogged myself, so whipping is mine all this evening if necessary, but not really, because this piece of legislation is not about pointing fingers, but is one that we think is very progressive, and in itself, it does not answer all the challenges that we have experienced with workers' rights over the years, but baby steps. Before we can get to the door, we have to pass one pew and then the other and then the other. So we will get there. I will try not to repeat a lot that Minister has said, but I will touch on some of the areas she has mentioned just to whet your appetite and prepare you for the questions we know that you'll have buzzing for us. I was really hoping to sit at the very end where Mr. Earl is, in the hope that by the time it came to me, I would just say ditto, ditto, ditto. But that didn't work out. Minister spoke earlier about the statement of employment particulars, but I want to touch on four areas to be included. A job description. So often we have workers coming to us and they express, well, this is what my job is, X or Y or Z. When we go to a meeting with an employer, the employer often expresses a different understanding of what the worker's job is. Sometimes genuine, sometimes not. And what the legislation does is levels the platform. An employer now has to issue a job description, which workers then will sign on to. If at any point in time there is some amendment to that job description, then that amendment has to be signed on to as well. Otherwise, when we are presenting our arguments, it goes to the Labor Department, it goes before an employment rights tribunal, then what is there signed to in black and white is what holds. So for the last couple months and for the next few months or so, employers will have to get on stream and make sure they issue workers' job descriptions. So workers, for you, it is in your interest to make sure when one is brought to you, if it does not represent what you know you do, then that is the time to challenge it before you sign it and then come to us saying, well, this is not what I do, or in the case where you're not organized by a union, you're going to the Labor Department and expressing concern. So that's the first one I would like to mention. The minister also mentioned about the rate of wages that should be included. And I said I wouldn't repeat, but this one is worth repeating. I would like to caution all workers in here to make sure you check with NIS periodically to ensure that your NIS earnings, your NIS deductions, are being paid into the National Insurance Department. 2 Sundays ago, on the 7th of July, I was in a meeting with a group of workers, and there was one worker expressing to me, having been employed with a company since 2005, she proceeded on maternity leave in December last year. Her maternity leave ended at the end of February this year. She was only receiving her maternity benefit 2 weeks prior to that meeting, sometime at the end of June, therefore, because the employer had been deducting her NIS contribution, the employee's portion, but had not been submitting it. So when she called NIS after a while not seeing her first check come in, or any check for that matter, NIS was asking the question, who are you? So then she had to be saying, well, I was with this employer, and there had to be a lot of back and forth. So don't assume that what is supposed to be done is being done. In our case, a lot of employers deduct union dues. I shouldn't say a lot. Some employers deduct union dues and they don't submit them. NIS has indicated strongly that their relationship is with the employee. So the employee now has to go and get that information for herself, bring that to us. The other one that I wanted to highlight under the statement of particulars is that any agreements reached within the collective bargaining process should now be mentioned where they relate to your statement of particulars. So, although in Barbados collective agreements are still not legally binding, and that is something you may want to ask further, that I will not use up time in my 20 minutes. But although collective agreements are not legally binding, what the Act does now is where there are agreements that relate to your statement of particulars, these must now be mentioned up front, so that indirectly it means that there are aspects of our agreements that are now legally binding once they're mentioned up front. So we get more to that. And then disciplinary procedures. There are employers that would want to just get up in the morning, as you've heard, and say, you've been doing this all along, out you go. Traditionally, by custom and practice, we have argued for progressive discipline, and now progressive discipline, meaning that you start off with verbal warnings, you go to written warnings, and so on. This is allowed for under the Employment Rights Act. So if you get in late this morning, tomorrow morning, because you were at Messiah's house and the minister's presentation kept you back so long, because I'm not going to cut mine because she went over. It means, therefore, that when you get into work late, an employer cannot just terminate you because you're late, unless you have had a history of lateness in the 12 months period preceding tomorrow's incident. Anything prior to a 12-month period should be expunged. Hope that does not mean, of course, I won't be speaking to you in here, but there are some employees that might count and say, well, I ain't got no warning for the last, let me see. So I could start back my bad practice in October. You don't always deal with saints. Then the minimum period of notice. What I want to touch on here is that when terminations are being contemplated before the act, before this new era of employment relations, when terminations were being contemplated either by redundancy or whatever form of dismissal, a notice period of 4 weeks, 2 weeks, or 1 week was normal in the case of where the employee was monthly, bi-weekly, or weekly, and where the contract specified otherwise for certain levels of job might be 3 months or so. But what the Act does is specify how notice should be allowed, because if you were a weekly employee and you were employed for a company for 15 years, you think it's fair that if they want to make you redundant, they only give you 1 week's notice just because you were weekly? But a monthly person who was employed for 2 years or 3 years, they get a month's notice by virtue of the fact that they're monthly. So what the Act now does is tie notice periods to years of service. So it does not matter whether you are weekly, bi-weekly, or monthly. The Act makes provision based on your years of service, and I could get into that with the questions that you asked on it. Then the right not to be, before I go on notice period as well, persons, I'll come back to that when I touch on the Severance Payment Act. Sometimes my brain is miles ahead of my tongue. All right, the right not to be unfairly dismissed is one which for the labor movement is one that we were very excited about, because when it comes to layoffs or when it comes to situations of redundancy or where individuals were under fixed contracts, those are instances in which the union would normally be called upon to answer a number of questions. I'll start on the last one, where an employee may have been on contract for 2 years. The end of that contract comes, the end date comes, and the employee is not being, the contract is not being renewed. And there were employees that would have questions for us. Would I still need this job? They didn't have any complaints with me. Why is it that my contract is ending and they're starting a new contract with somebody else? And now the Act makes provision that the employer will have to answer those questions. Before, we had to operate on the basis, well, your contract ending, not much we could do about that. But now even those instances of dismissal are, I don't want to say protected in itself, because the employer's decision can still be legitimate, but the employer is now answerable to that, and you'll find it under the unfair dismissal section of the Act, Part 6. And then layoff. We, as you heard in the presentation before, a lot of our methods or approaches to dealing had to do with custom and practice. So there is a controversial one that the unions traditionally have favored: redundancy and layoff based on, anybody knows? Last in, first out. Something that a lot of employers and employees, depending on which side of the fence you're sitting on as an employee, will oppose. But custom and practice dictated that that was the approach to be taken. And custom and practice, or the unions would normally call for consultations before any such action is taken. What we went a step further after, not simply demanding it at the level of the table, but the social protocols. When what the labor movement sought to get enshrined within the protocol, which again is under the system of voluntarism, not legally binding, but it takes it away from the bilateral approach, the bipartite approach of just the union and the employer, and it gets the government into the mix as well, through the Labor Department and the Ministry of Labor. So what we would insist on is that if you're going to have redundancies, layoff, that there should be consultations. The Act proclaimed on the 15th of April, a very significant date for workers this year. What the Act now says is that consultations must take place no fewer than 6 weeks prior to the layoff, the proposed layoff or proposed redundancy. So what that does now is allow some time for employees and their representatives. And I should stress that it's not only about unions representing employees, because if you're not a member of a union, which you should be, and my union is obvious, I will speak favorably of mine, where it applies to you. But you don't have to be a member of a trade union, or if you are a trade union member, you do not have to rely on your trade union rep. You can also take a friend. You can decide to do it yourself, not advised, or you can use the services of a lawyer, much more expensive than $26 a month. But what those consultations would involve or might allow for is for the business reconfiguring its approach in a way that the redundancies or the terminations might no longer be seen as being necessary or not impacting the numbers that they intentionally thought they could impact and so on. So there is scope. But while all of this sounds glowing, one of the questions that might be going through your mind is, are employers really going to honor what is in the law? And if they don't honor what the provisions that are there, what then? Or when an issue has to go before an employment rights tribunal, how long? Does it really make any sense? Because by the time they get around to my issue, then it might be a red herring. And we will find situations in which we anticipate situations that there might be delays. And this is where the minister now has the responsibility to ensure that there is enforcement of the act. One of the deficiencies that labor sees, because you have a labor department that is staffed with personnel that have to look out for health and safety, look out for the Employment Rights Act. And although the Act is clear on time frames within which, like 3 months generally for submitting a complaint to the Employment Rights Tribunal through the Office of Chief Labor Officer, and then once it's at his level or that level, then there's 42 days generally for that office to make progress on an issue before passing it on to the Employment Rights Tribunal. But although that sounds good, you can only work within your means. So one of the gaps that we foresee is that there can be some delays occurring at the level of the ministry if you have a number of complaints that need to be handled at one time or the other. Then there's some that might argue why not go through the courts. Go through the courts in Barbados is what I tell workers when I'm dealing with a matter on their behalf. You come to me sometimes 5 months later, I can't understand. Ever since I come to you with this, and then the progress, and whatever. But you are but you end it off, and I'm saying you, not you, but workers. I go into a lawyer, and I sometimes am facetious enough, if you want to say it so, to tell them, see you when you come back. Because you go to a lawyer, and you pay your $300 per half an hour or whatever the fee is, and then your matter is still tied up in the court for years and years. And I like sometimes for workers to experience it, because when they come back, they're more humble and less cantankerous and insistent that a matter be resolved in 3 weeks. For each person, their issue is the biggest and most important issue. But we too, like the Labor Department, have constraints and would need to prioritize on issues that demand immediate attention. So for those who, like the gentleman in the middle in the green shirt, has seen the act or have an act, some of the questions that you should be prepared to discuss with us should relate further to layoff and redundancy, to specifics on notice period, given that notice must now go from 2 weeks or 1 week for persons employed less than 2 years and up to a maximum of 10 weeks. So where the maximum traditionally, in most cases I should say, was 4 weeks, it now goes up to 10 weeks for persons employed more than 15 years. So these are the sorts of issues, just whetting your appetite, that you will want to get into.